actually not really continuation of hearing, motion regarding show cause, as well as issues regarding attempted reinstatement of parenting time. The parties are present in the courtroom, appearing on behalf of the plaintiff's attorney Eric Miles, appearing on behalf of Mr. Wiederhold, Melissa Reddick, who appears by the Zoom application. Just a moment ago, off the record, I inquired at the front of the court of Ms. Schultz regarding the status of this case. She apprised the court, and I hope both counsel heard the statements. Did you hear those?
Yes, Your Honor.
Yes, Your Honor.
All right, thank you. And so that's where we are at this point. Let's begin first with the motion filed by Mr. Miles.
Thank you, Judge. Well, Your Honor, I'm glad to hear Mr. Wiederhold kindly posted a payment for child support. It's unfortunate that we had to file a motion to enforce that. Pursuant to the judgment of divorce, any motion that is needed to be filed to enforce the judgment of divorce or child support obligations are subject to attorney fees and costs. So I still would recommend or request that attorney fees and costs be assessed against Mr. Wiederhold for us having to file the motion to begin with for enforcement of those support obligations. There are also other issues, Your Honor. The parties had agreed, and I know if it's with regard to extracurricular activities, I know if it's not in the order, the court can enforce an agreement between the parties on, say, a 50-50 split of extracurricular costs. However, there was an agreement between the parties, and Mr. Wiederhold has failed to adhere to his 50-50 split to the tune of $423.32 for extracurricular activities and $254 for school lunches as well. Again, I'm happy and pleased to hear that he finally got his child support caught up, albeit at the 11th hour, but he still owes those costs for school lunches and extracurricular fees as well. The judgment of divorce does state that if a motion has to be filed by either party to enforce the judgment of divorce, then the movement party is entitled to their attorney fees and costs. So although he paid his child support, I'm still requesting $1,000 in attorney fees and $20 for the motion fee.
What's the 1,000 based on?
My time in preparing the motion, the brief, the exhibits, getting all the exhibits from my client. She had to go to the various medical providers to get those statements. My drive time is an hour and a half each way. So if we were to add it up, it would actually probably be more than $1,000. But I think $1,000 is reasonable.
And as an officer of the court, I'm not trying to break into the attorney-client relationship here. However, that would be the amount that you would have billed for today's service, regardless, correct?
Well, yes and no. Is
still more client?
Yes, yeah, oh yeah, definitely. But is the court referring to the other motion that's being heard?
No. I'm just talking about this one that you filed regarding enforcing this.
Oh yes, those costs were incurred, and my client is obligated to pay those. Thank you, Judge.
You're welcome. Ms. Reddick?
Thank you, Your Honor. As it relates to the default of the child support, Your Honor, I recognize that my client fell behind in child support, and I know this court's extremely familiar with the term debtor's prison. My client is self-employed. He does everything he can to earn a living, support his family, pay all of his financial obligations. Recognizing that he got behind in support, he scratched together everything he could to get that paid in full, to show the court his best efforts to comply with everything that he is able to. I understand Mr. Miles's argument as it relates to the attorney fees. I'm looking at the enforcement expenses provision on page 11 of the judgment. It's the second paragraph down. And it indicates that if either party is found in default of the performance of any terms, provisions, or obligations, and it becomes necessary to enforce, the party to be found in default will pay said expenses incurred in connection with the enforcement proceedings. So I would ask the court to utilize its discretion as it relates to the child support. Obviously, that's this court's choice what it chooses to do with those things, but it's simply a matter of my client just doesn't have all of the funding that he would love to have for his family. And I don't mean this with any disrespect to Ms. Dom. She's worked very hard to get where she is with her career, but she has a wonderful career that pays very well. My client is a self-employed individual with in the auto industry. So that's all I can say as it comes to that point. As it relates to the remainder of Mr. Miles's arguments, my client disagrees with the fact that the parties had a verbal agreement as to all of the charges and the things that he's bringing up to the court. My understanding and my client's understanding were that the children were supposed to go to public school years ago. With public school, my client does have some state benefits afforded to him. The children would have likely been afforded free lunches. There wouldn't be a lunch bill. It was Ms. Dom's unilateral decision against my client's objections, which they have joint legal custody, to maintain the children at private school for a period of time. They are now in public school. So I would say that any lunch expense that she incurred could have been avoided for several reasons. I'm not sure with the parochial school if you're able to get lunch paid for if your parent has state benefits. I don't know that because I haven't encountered it. But there was no court order that requires it. There was no agreement there. So I believe that expense should be bared by Ms. Dom. As it relates to extracurriculars, it was pled in a generality. But in addition to that, there's no order that indicates anything with extracurriculars. I read through the orders, it's not there. And so even if the parties did have some verbal agreement, which my client contests and that says that they did not, there is no order that requires him to pay half of whatever Ms. Dom chooses to put the children in unilaterally without my client's consent. In addition to that, I don't think Mr. Miles mentioned it in his argument, but in his motion, he does address that there are some past due healthcare, dental expenses, things of that nature for the children. As I said, I didn't hear him say anything about it today, but it was written in there. In my response, I indicated the friend of the court has a very clear procedure of how these things are handled. If there are expenses that were not submitted to the friend of the court and it's been beyond 6 months, my understanding that that's mom's expense to bear because she didn't follow the procedure and request reimbursement. If there are expenses that are less than 6 months old, that can be brought to my client's attention, put through the friend of the court procedure, whatever, he's happy to pay his percentage pursuant to the UCSO and the judgment of divorce. But if Ms. Dom sits on her hands and has expenses that are 2 years, wants money for them, it's no one's fault but her own if she didn't follow procedures that are laid out very clearly. So obviously, like I said, I have to leave it to the court's discretion as it relates to attorney fees. My client doesn't have extra money. If my client had the money to be current on everything, he would be. He means no disrespect to this court whatsoever. So we would respectfully ask that the court deny mother's motion in full and utilize discretion, but we would respectfully ask that my client not be assigned attorney fees for mother. If he is, I would ask the court to take into account, we have our motion for parenting time pending for today, no matter what. Mr. Miles would have to travel and appear no matter what. So if the court does grant any attorney fees, I would ask the court to limit it specifically to the issues surrounding the motion for contempt that he filed related to the child support and take into consideration that he would have traveled here today anyway. Thank you.
Yes, briefly respond, Your Honor. With regard to the funding, with all due respect to Mr. Wiederhold, it is not the onus of that should not fall at my feet, my client's feet. He is obligated to make these payments, and he clearly has the funding. He put a brand new pool in at his home, which is very expensive. He has the means to pay these, Your Honor. He just chooses not to, or he chooses to do it at the 11th hour after a motion's been filed, the day of the hearing, or a few days before the hearing. Additionally, I failed to mention, which I should have, there is also a $1,200 fee for a dental fee for braces for the minor children.
Is that submitted to the friend of the court pursuant to their policy?
I don't believe so. I don't believe so, Judge, but to that point, the court can obviously deviate from friend of the court policies. It's a friend of the court. They act, pursuant to the court's directives, and the court has the ultimate say on that. Part of the issue is Mr. Wiederhold would be behind time and time and time again And my client just got tired of submitting everything to the front of the court and nothing being done about it. So finally I said, well, get me all the stuff you have and we can file this motion and have the court address the issue directly. So with regard to his alleged inability to pay, that's simply not true. He makes enough money. He bought a brand new pool for his house, which obviously was not a necessity. And he only makes his payments again when we have to drag him into court to do that. So I think the court should send a strong message to him and levy sanctions against him so that we're not in front of your honor every month or every other month trying to compel him to pay his child support and his other obligations.
Mr. Miles, how do you respond to the comments of Ms. Reddick regarding the judgment being silent regarding extracurriculars as well as school lunches?
I do agree it's silent, Your Honor, and I do agree that for the court to enforce it, it would have to be included in an order. Me and my client merely wanted to show the court that not only is he failing to do what he's obligated to do under the judgment, but also failing to provide financial support for those other things as well, which my client is currently bearing the full cost of. And they did at one point have an agreement, was never reduced to a writing or a court order. So I understand the court's hands are kind of tied on those sorts of issues. I expected that, but I wanted to include that in our motion in case the court were inclined to enforce that agreement or to at least provide some context for why we're here today as well.
All right. You did make a comment, which was a little concerning to me, about the allegation that these things have been submitted to the front of the court and nothing done. Schultz, do you have any comment on this?
The front of the court office, with regard to child support, issued a notice of arrears to Mr. Wiederhold on July 11th of this year. That document indicated that his account had a current arrears of $1,761.50 at the time it was issued. We then allowed time for payment to be made. No payment was made. So on August 14th of 2024, the front of the court office scheduled a show cause proceeding, which was set for September 25th, this past Wednesday. That show cause was set aside because payment was made on Monday the 23rd. However, as it relates to uninsured medical expenses, which includes orthodontics, our office has never received a request for reimbursement since the judgment action.
Your Honor, thank you, Judge. My client has indicated she submitted everything at the front of the court interview back in January. So I don't know if there was miscommunication or things got lost, but those things were submitted.
There were certain documents submitted with regard to medical expenses. However, it was not submitted in accordance with our policy, which does include a request for reimbursement form and paid receipts. So there was certain medical documentation that was looked at as part of the investigation process, but it was not a request for enforcement of uninsured medical expenses. There is a separate form and process for that.
Just to that point, Your Honor, I'm not sure if the front of the court advised my client that there had to be this separate sheet filled out. I would assume that if you're submitting medical bills to the front of the court, you're seeking reimbursement for those. And again, I might be talking out of school because I don't know if they did in fact say, hey, fill this sheet out and then we'll take care of it. But what's done is done. So I just wanted to bring that to the court's attention that it was in fact submitted. Maybe my client did not fill out the extra form she should have, but I think the court should exercise some discretion on that.
The only thing that I would add is our policies are outlined in the orders. They're posted to our website. We have hard copies of all the forms available.
Sure. Thank you. All right, this is a motion relative to expenses as well as attorney fees for enforcing the judgment of divorce relative to support. Clearly, support was not paid. Show cause hearings were scheduled. Motion was filed. Front of the court followed through as well. And fortunately, Mr. Wiederhold did not pay the support until this past Monday. Thank you for paying the support. And it's not for the court, it's not for mom, it's for the child or children involved. That's That's what's the deal. However, there was a motion filed, and the judgment of divorce is very clear regarding enforcement of motions by either party. So the court considers that as well. Regarding extracurriculars and lunches, there was a request for $423 and change, 32 cents, as well as lunches, $254, dental expenses. Also, obviously the attorney fees. Clearly, the defendant was not found in default, but clearly court finds him failing to pay child support timely. Clearly, that's why the motion was filed. As a result of the motion being filed in front of the court's actions, fortunately support was made, but at the expense of the plaintiff as well, for filing the motion as well as the filing fee. $20 is ordered for the filing fee. I'll address attorney fees in a moment. Regarding the extracurriculars and lunches, there's nothing contained within the judgment that the court can enforce. If there is something within the judgment of divorce that's in written form, the court will clearly enforce that. Unfortunately, a verbal agreement is not worth the paper it's written on. So if the parties agree to something like that, and they want it placed in an order, simply contact the front of the court's office. They will amend the judgment or order, place that in the file, and then we move forward. That didn't happen in this case. So extracurriculars and lunches will not be ordered. Relative to dental expenses, this court finds that a father is responsible for half of the dental expenses. However, when it comes to enforcement of those expenses, there is a policy that the front of the court follows, and this court also follows. And the court will not deviate relative to policy. If I deviate on one party, I have to deviate on other parties as well, and that's not fair to the individuals. So as a result, regarding the dental expenses are respectfully denied relative to recovery. However, if the dental expenses are within that 6-month time frame, they send it to the front of the court office, the front of the court will take action. And if they take action and it goes further, then it comes to me, I'll address it. But moving forward, regardless, you're responsible just as much as mom is regarding medical expenses. Relative to attorney fees, $1,000 is being requested on behalf of the plaintiff in this case, and the court does consider that within the judgment of divorce. Clearly, there's an enforcement mechanism. Attorney fees will be awarded in this case, however, not to the extent of $1,000. And the reason being, and Ms. Reddick makes a good point regarding transportation as well. There's another motion being filed today as well. That's the motion to reinstate parenting time. The court will reduce the request for attorney fees from $1,000 to $750. $750 in attorney fees, $20 motion fee will be ordered in this case. Mr. Miles will prepare the order, and that will address the matter regarding payment of that amount of money. At this point, I would say it needs to be paid within 90 days.
Very well, Your Honor. I'll prepare the order.
Thank you.
Thank you.
Let's address the parenting issue. Ms. Reddick, go ahead, please.
Thank you, Your Honor. As this court is aware, these parties have had joint legal custody. Mom has primary physical. They've exercised, as we've alleged in the other pleadings and put on the court record, they've exercised equal parenting time with their children for several years. Since last fall of 2023, mother pulled that back and went by the order, which indicates that my client has guidelines parenting time. So she pulled that back. Then we came to court under a motion that we filed. We were referred to the front of the court for an investigation regarding the parties' competing motions. In December of 2023, this court elected as a safeguard for the children to temporarily suspend fathers' overnight parenting time until further order of the court and conclusion of the front of the court investigation. My client's parenting time schedule remained the same pursuant to the guidelines, just not overnight. It ends at 8 p.m. on his days. We are respectfully asking the court to reinstate my client's overnight parenting time with the children. It's our understanding that the children have been struggling. It's been quite some time since they've been able to go to sleep at their dad's house and wake up with their dad. They've been struggling with that. It does extremely limit some of the parenting time they should have together. I know the court had the very best of intentions in placing its order, so I don't mean any disrespect there. But we've gotten to a crux of this has gone on so long that it's having a detrimental effect to the opposite of what I believe is in the best interest of the children. There have been no concerns whatsoever these entire 9.5 months that there is anything going on at father's home, that the children aren't taken care of, that they don't have necessities of life, that there are inappropriate individuals there, that anything of that nature is happening. And I do mean this with all respect to the court and to mother's position. My client has had daytime parenting time, and that's gone wonderfully with the children, and they enjoy that with him. If everyone's sleeping at the house at dad's house, they're sleeping. I don't know what it is that could be occurring during their sleeping hours. There's no one else in the home except father and the 4 minor boy children that are 2 with Ms. Dom and 2 of his other children who are even younger than the 2 at issue here. I don't know what could possibly occur that wouldn't occur during the day. I would think it's safer, for lack of a better term, during sleeping hours, because they're just that, they're sleeping. And then they have the opportunity to wake up with their father, have him put them to bed. They're missing out on that normal day-to-day life with dad. And from our perspective, unintentionally, it's frustrating that relationship between them. The court's aware that the friend of the court recommendation has been filed. There have been objections by both parties that are pleadings that this court has been able to read. So I think it's apparent the content of that recommendation, and I know it's just a recommendation at this point, but it's my understanding that everyone knows that the friend of the court has no objection to this occurring as well, that it didn't see any safety concerns. I do know that we have these objections pending, but I just think that that's worth what it's worth because the friend of the court did a lot of hard work. When I filed this motion, it had been 280 days since that order went in place. So more than 280 days since the kiddos have been able to have their dad kiss them goodnight or tell them good morning. And it is really strongly affecting them. This court knows the law well, but the Michigan Child Custody Act presumes that it's in the best interest of kids to be able to have a strong relationship with both parents, unless there is a very clear reason as to why that should not occur. We don't have that here, and we do have mere allegations, of which none new have been brought up since last year, before that December 15th hearing. So with that, and with MCL 722.271F, this court's aware that it has the authority to take any action considered necessary in a particular child custody dispute, as it relates to the best interest of the children. 722.271C discusses the established custodial environment. The kids have it with both parents. We know that they always have. They look to both of them for love, affection, guidance, discipline, necessities of life, parental comfort. By reinstating father's overnights, we're not changing any of that. We're just going back to what the kids know. And obviously, Shade v. Wright discusses the preponderance of the evidence standard, which is 291 Mich. App 28, a 2010 case, indicating that when we're just asking to change some parenting time, and we're not even changing, we're asking to go back to what is ordered in a final order as opposed to a temporary order. But the court does only have a preponderance standard to determine if this change would be in the best interest of the children. I know that we have a full evidentiary hearing coming up in the middle of November. I don't think these kids can sustain that much longer, Your Honor. So I think it's a good a way to start, that if the court were to grant dad overnights, then we've got some time before that hearing. And if there is anything that goes to the south, the boys are in counseling, we plan to have the therapist testifying, then we've kind of had a little bit of a test drive, for lack of a better term, of if overnight parenting time really isn't in their best interest, as we believe that it is, so that we can have the best handle possible for that November hearing. But I just don't think the boys can handle waiting that long. They're really missing their dad. It's emotionally affecting them in a lot of ways. So respectfully, we would ask that pending that November hearing, that we reinstate dad's overnights pursuant to the friend of the court guidelines, and then take up the rest of the matters contested by the parties at that time. Thank Thank you.
Ms. Reddick, you made mention of the front of the court recommendation. That's not been brought out at this point yet, correct? Unless it was at a previous hearing, because I don't recall any front of the court recommendation, nor do I even talk with the front of the court regarding the recommendation while the matter is pending.
And I know the court absolutely does not do that. I know that we've discussed it between the court, myself, and Mr. Miles, but what I'm getting at is when Mr. Miles and I both filed our objections to the front of the court recommendation, those are public pleadings and those went in the court file, and I know the court reviews everything. So we both laid it right out there that the front of the court had indicated that they supported overnights for father. So because it's in a public pleading and it's right out there and the court had the ability to read it, the public can read it. I didn't think that it was wrongful or unethical in any way to mention that because we've already put it out there for everyone to see.
One of the reasons the court back in December made the modified order was regarding the individual in question. What's going on with that?
That individual is not around the children whatsoever. He's not at Mr. Wiederhold's house. Obviously, it's a small community. He's still in the community, but he's not there. He doesn't have access to the family. He doesn't have access to the children, and it's maintained that way since quite some time ago, prior to these pleadings ever even being filed by either party.
Thank you, Your Honor. I take exception to a few of the comments Ms. Reddick made, particularly with regard to the current state of the minor child's health and well-being. The children have made drastic improvements from when Mr. Wiederhold's overnights were suspended. In fact, they both have all A's in school right now and have zero issues regarding discipline, behavioral issues, no issues at all. This is head and shoulders above where they were when they were having overnights with Mr. Wiederhold. As well, the therapist for Ian Wiederhold, Ms. Reddick and I spoke with her, and consistent with her letter, which is attached as Exhibit A to my response, she has serious concerns about these children. Well, Ian specifically, she only sees Ian.
I apologize for interrupting. I object to Mr. Miles bringing up anything that the therapist has said at this point in time. It's hearsay. That exhibit has not been entered as an exhibit with this court. And anything that she indicated, she's not here, she's not testifying at this point in time. So I don't think that it's right to be provided to the court right now.
I have to agree.
Well, Your Honor, that's why we need our evidentiary hearing. So the court can look at all of the evidence and consider all of the evidence, not just the statements of Ms. Reddick regarding J.E. was his initials, that he's no longer there and that issue's been taken care of. Mr. Wiederhold knew of that issue with J.E. for 2 full years, and it was only by happenstance that my client found out about the issue, immediately reported to CPS, and that kind of was the genesis of why we're here today on this motion. The court properly, because what we're looking at is the safety and health of these children, the court properly in December determined there was enough at that time to suspend Mr. Wiederhold's overnights. Now, he's been getting his kids regularly, there's just no overnights. So to say that, oh, they miss him and you know, they never get to see him, that's just untrue. They see him all the time. They just don't have overnights with him. At this point, nothing has changed since that hearing in December. And in fact, there's only further evidence that the court was correct in suspending his overnight parenting time at that time. I would recommend that the court put a pin in this issue until the court hears all the evidence at the November 14th hearing, where we will have witnesses come in, including the therapist, and testify to how well the children are doing in school, in their personal lives, how they treat their mother, how they treat other people. It's amazing, Judge, how much improvement they've made in such a short time. And so I would request that the court seriously consider those factors and put this issue off to where it should be, quite frankly, which is at the evidentiary hearing where the court can hear all of the evidence. Thank you.
Ms. Reddick, your motion, so you have the final comment.
Thank you, Your Honor. Just briefly, my client has always maintained in pleadings, in argument, and everything to do with this case that the issue with J.E. is specifically limited to my client. It's always been issues related to my client's property, nothing to do with the children. And so my client exercised due diligence in ensuring that he had the verification he needed for that situation. And we placed that on the record in December that my client surveilled and found out what he needed to find out. He addressed it directly, and that individual has been prevented from access from his home. He's never cared for those minor children. We already placed that on the record in December. So I understand that it is a topic that is uncomfortable and concerning for everyone, and I don't diminish that at all. But our proofs will show that it was limited to my client, not the children. There have not been new allegations brought to the court's attention, to my attention, by pleading, by argument, anything, since last year, that there is anything allegedly inappropriate, unsafe, whatever word you'd like to insert there, at my client's home. Things have been going quite well with my client's home. I appreciate the fact that the children are doing great right now in school, and they don't have any behavioral issues at school. That's wonderful. I wish that that were true at home as well. They're very much struggling emotionally, and dad spends a lot of time with that. We can't sit here and say with certainty, or even any minimal certainty, that whether the children are doing well in school or poorly in school, that can be tied to whether or not they have overnights with their dad. We don't have any evidence on the record whatsoever it relates to that. So that's a dangerous leap to say they're doing great in school, so it must be because they haven't had overnight parenting time with dad. Maybe mom and dad are doing extra help with the boys. Maybe the boys are feeling confident as it relates to academics. We don't know. But I think it's dangerous, and it's not supportive of the evidence that we have so far to say that that's the reason, and so dad shouldn't have any overnights. If there were any new concerns that were brought to this court's attention, I would understand the need to not have parenting time reinstated on an overnight basis, but that is not the case here. Everything's been absolutely fine. So I recognize Mr. Miles has to advocate for his client, and I respect that. But these children are what our goal is for all of us. These children are safe at dad's. They deserve this parenting time with their father. There's nothing that has been proven, and the last nearly 10 months have shown this court nothing new is happening. There's nothing there. They're happy, they're safe, they're supported at dad's. They need to have this overnight parenting time now. They don't understand that we'll be at court in 2 months, and they shouldn't. But the longer we wait, the more we're frustrating the relationship, the more we're weakening that bond, and the more the children are denied that relationship with their parent that the Michigan Child Custody Act very intentionally put in place. So because these are mere allegations at this time, and there's been nothing new to cause anyone concern, we would ask that the court reinstate that overnight parenting time. And we do have that opportunity coming up in a month and a half to have the court readdress it, or via an emergency motion if something should come up, to correct it again. But at this point in time, my client and I believe that overnights are what's in the best interest of the children. We would ask the court to allow that until such time as we return in November. Thank you.
Thank you. All right, this is a motion to reinstate parenting time. Back in late December of last year, the court had suspended overnight parenting time with the father based upon information contained within the motion and documentary evidence presented, as well as videos. The court did that for the purpose of protection of the children. That is, number one priority is the children when it comes to their health and welfare. And certainly the court was alarmed enough to modify the parenting schedule of father. Motion has been filed to reinstate that. There was a friend of the court recommendation. The court can take judicial notice of both counsel, and even our discussions that we've held together, the three of us, so to speak, relative to the friend of the court's recommendation. So the court's aware of it. But this matter is scheduled for sometime in mid-November, November 14, I believe, before the magical day for some people. I guess I have to look at it from the perspective of, I have one attorney saying the children aren't doing well. I have another attorney saying that the children are doing well. I can't consider the therapist at this point because it would not be fair. There's no way of cross-examination of the therapist. I didn't hear, for instance, from Ms. Reddick on behalf of her client that the children aren't doing well, or that's the issue. She said they may be doing well, but there may be other reasons. On the flip side, there was nothing commented back regarding any emotional issues relative to the children through Mr. Miles. So essentially the court's operating in a vacuum relative to even moving the needle here regarding the parenting time. I have to look at proper cause or change in circumstance. And at this point, because the court cannot consider very much, I'm getting equal information from one side and the other side. As a result, I don't find proper cause or change in circumstance. We continue with the prior orders that are currently in effect, and we will proceed to resolving this matter at the November hearing. And at that point, it clearly will be addressed, and we will have final orders respective to that. So respectfully, the motion is denied. Ms. Reddick, if you present an order to that effect.
Thank you, Your Honor.
Time and date set for hearing. Ms. Hume is present. She is in pro se. Court calls Nicholas David Hume. No response. The court inquired of Ms. McNames, Deputy Court Administrator, relative to Mr. Hume checking in via Zoom. He has not checked in this morning. The court also notes that there was a default entered in this matter on August 23, 2024. As a result of the defendant's failure to appear, the matter being scheduled for 9 a.m. It is currently 9:46, and we will then be proceeding under in default in this matter. Ms. Hume, would you please raise your right?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help God? Yeah.
Thank you. Ms. Hume, you look a little alarmed. It's okay. We'll try to make this as simple as possible. Would you please state your name for the record?
Brittany Hume.
And you're the plaintiff in this matter, correct?
Yes, sir.
Have you lived in the county of Huron at least 10 days in the state of Michigan, at least 180 days immediately preceding your filing this complaint for divorce?
Yes, sir.
At the time you filed this complaint for divorce, was your husband a resident of Muskegon County?
Yes.
All right. And is it true you were married on May 24, 2024 in Harbor Beach, Michigan by a person authorized to perform marriages in this state?
Yes, sir.
And you stopped living together as husband and wife on or about July 22nd of this year?
Yes, sir.
Prior to the marriage, your last name was Dondino?
Yes.
And the defendant has always been known as Nicholas David Hume?
Yes.
Are there any minor children?
There are not.
I have to ask, are you currently expecting?
I am not.
You've alleged in your complaint for divorce that there's been a breakdown in the marriage relationship. To the extent that the objects of matrimony have been destroyed, there remains no reasonable likelihood the marriage could be preserved. Was that true at the time you filed the complaint?
Yes, sir.
Still true today?
Yes, sir.
Briefly, in your own words, can you state to the court why you feel the marriage cannot be preserved?
We are in two different lives. He lives 4 hours away and we have no communication. We don't talk. When we do talk, it's just an argument.
Is there any chance of reconciliation?
There is no chance of reconciliation.
If the court did not grant you an absolute judgment of divorce, would you be willing to resume a husband-wife relationship with the defendant?
No, I wouldn't, Your Honor.
Thank you. You have submitted a proposed judgment of divorce, which would indicate that neither party would be awarded spousal support in the issues from regard, correct?
Yeah.
Regarding personal property, each party is awarded the personal property currently in their possession to be fully responsible to pay any debt related to the property, with the other party having no claim to that property. Is that correct?
Yes, Your Honor.
Has the property already been divided?
Yes, Your Honor.
All right. Is there any property that has both names on it?
No, Your Honor.
Thank you. Are there any debts to be divided?
No, Your Honor.
Each party would keep their respective vehicle free and clear from any claim of the other, just like the personal property?
Yes, Your Honor.
All right. Do you own any land?
I do not.
Does he?
Not that I know of. No.
Okay. Are there any pension, annuity, retirement accounts?
No, Your Honor.
Does any party carry any life insurance that has cash?
No, Your Honor.
Are there any other assets or any other debts that you're aware of that we've not discussed?
No, Your Honor.
Do you wish to have your previous name restored?
Yes, Your Honor.
You're welcome. Based upon the testimony presented, the court finds that the statutory grounds for divorce have been established. Therefore, judgment of absolute divorce is granted to the plaintiff, Brittany Hume. For the defendant, Nicholas David Hume, I make the finding there are no minor children. Parties, Neither party's awarded spousal support. Divorce judgment shall include property division outlined on the record. And the plaintiff is restored the surname of Donino, Dondineau. Ms. Donino has submitted to the court a proposed judgment which comports with the testimony presented. The court is going to execute that judgment at this time. Dated today's date. That was September 12th. And Ms. Donino, what will happen next is Ms. Hatch will get this filed to the county clerk's office. You'll be able to get a copy of your judgment of divorce today, and that will take care of it. Was it harder than you thought?
No.
Try to make it simple. So at least you're smiling now. You seemed a little nervous there at first. I wish you the very best. Good luck to you. Parties are present. Plaintiff, however, is represented in this matter by attorney Amanda Rosenbach. Will both parties please raise your right hand? Ms. Rosenbach, this is your motion. You may proceed.
Preliminary matters. I don't know if the court has received Ms. Possessive, I received it late last evening after it was filed. I would have to ask the court to strike the answer in whole because it does not apply to court rules. The stated attachments were not applied. And additionally, if the court doesn't strike the entire answer, I would have to ask 52, 53, 70, 71, 72, 73, 74, 77, and 81 are non-responsive, and some contain allegations that aren't even in the plea. So I'd ask specifically the court doesn't strike the entire answer, that those provisions be struck from the plea.
Any response?
I forgot to even put them in there. I have them with me. I forgot when I filed it yesterday. I just got work and it was all chaotic when I brought it up here.
Just that they don't comply, Judge, I would ask that the answer be struck in total, and again, if not, the numbers that I stated on the record be struck specifically because they don't respond or comply with the rules.
All right. The numbers again?
52, which is actually 47 F in the complaint. 53, 70, which is actually 56G in the complaint. 71, which is actually 56H in the complaint. 72, which is actually 56I in the complaint. 73, which is actually 56J in the complaint. 74, which is actually 56K in the complaint. 77, which is actually 56N in the complaint. And 81, which isn't even in the initial complaint.
All right, relative to the answer in this case, court will strike 52, 53, 70, 71, 72, 73, 74, 77, and 81. However, the court will allow the defendant to amend her answer and to the party within 14 days with the proper attachments.
So 14 days, Judge?
14 days.
Okay.
So let me try to mark those off here as well.
As the court is aware, it's a lengthy pleading because for a period of time, we didn't know where the defendant was. I've had an opportunity to talk to my client, length. I've had an opportunity to meet with the defendant. She represents herself. I advised her that I am not the lawyer, I'm not there to give her legal advice, but I went through our proposed order with her, Judge. I will place those on the record. As I said, there are two issues that will need the court's guidance on. The parties agreed at this point, however, that they will share joint legal custody of the minor child. The parties agree that my client will have temporary sole physical custody of the child during the pendency of this case until further order of court or agreement of the parties, and that the friend of the court will begin a recommendation for custody, parenting time, and child support. That agreement does not change or modify any established custodial environment at this time. The defendant has agreed within 7 days she will provide proof of her own residency, a lease or a mortgage with her name on it. She will provide that to the friend of the court and counsel of record. The defendant has advised that she does not wish to work 40 hours a week. We would ask that the court impute 40 hours a week income to her because she's advised that she has the opportunity to do that. The parties have agreed that once the defendant establishes her own housing through the proof of this lease with her name, that they will enjoy holidays pursuant to the friend of the court guidelines, parent A, parent B schedule that will be attached and incorporated by reference to the schedule.
Would be A, would be B.
That's A, that's B. The parties have agreed that a responsible adult may transport the minor child for parenting time. The responsible adult is defined as someone over the age of 18, known to the minor child. They will provide each other advance notice if that's done, and the responsible adult cannot violate any provisions of this order or any other order of the court. The parties will agree not to sabotage or utilize, not to sabotage the other's relationship with the child or utilize the child for a means of communication, and not to discuss parenting matters in front of the child until the child is of sufficient age to be a party to those discussions. The parties have agreed they will put the minor child's needs first and work together to ensure the child attends activities consistent with his age and development. The parties have agreed that the child will not be in the presence of any convicted felons, anyone on parole, probation, central registry, sex offender registry, or animal abuse registry. Neither party will consume alcohol 8 hours prior or during parenting time. Neither party will consume controlled substances or illegal drugs 24 hours prior to or during parenting time except as duly prescribed. Mom did advise that she is taking a prescription medication, but that she's taking it within the prescribed level. The minor child will continue at his current school and he will remain at that school. The parties have agreed that that's in his best interest, that being Harvard Beach Elementary. The parties will have no third party or non-relative third parties, no non-relative third parties of the opposite sex present during parenting time until further order of the court. That does not preclude family members, that precludes boyfriends, girlfriends, folks of that nature. The parties both agree that they will complete the online SMILE program with Tarrant County Friend of the Court within 30 days of the entry of the order. And the parties have agreed that they would like the option to utilize the alternative dispute resolution services of the Tarrant County Friend of the Court when available. The parties have agreed that the child's domicile will not be moved out of the state of Michigan without prior approval of the court, and neither party or an agent will move the child from the United States without order of the court. The parties have agreed to notify the Friend of the Court within 21 days of anyone change in the child's address. And the parties who have custody or parenting time will not change the address of the minor child more than 100 miles from the residence at the time the complaint was filed. The parties are granted reasonable time, rights of talk time with the minor child. If they can't agree, it'll be Tuesdays and Thursdays at 7. It does sound like from my conversation with both parties, Judge, that's pretty frequent. If the child asks to talk to somebody or the parent calls, the child does that. The parties are going to utilize app close for all purposes of non-emergency communication. Parties are prohibited from speaking in a negative or degrading manner or allowing others to do that in the presence of the child, including but not limited to verbal, texting, and social media posts. As I said, it's being referred to the Friend of the Court for an investigation. The parties have agreed child support will be effective the date of the initial filing of divorce. The parties will comply with all provisions of the Hague Convention, and neither party will take the child to an area that doesn't follow the Hague Convention. With regards to the marital estate, the parties have agreed to be restrained from disposing, selling, destroying, hiding, or damaging or ruining the personal property of the other party. Mom is going to provide my office a list of the items she wishes to retrieve. My client doesn't anticipate there being any argument about those items. He's going to begin moving those to the garage. We'll set up a mutually agreeable date, and she's going to come and retrieve those items and take them to where she's staying. The parties are restrained from allowing any insurance policies to lapse or any benefit policies to lapse or be canceled during the pendency of the divorce. The parties agree not to file any tax returns without the approval of both parties or until further order of the court because we're coming up to tax season. The parties are ordered to maintain insurance on the vehicles in their possession. Specifically, Mom has a Voyager 2021 in her possession that my client has liability for. He's a joint signer on the loan, we believe. She has indicated that she has insurance on it. She's going to provide proof of insurance to my office within 7 days. She is going to refinance that vehicle within 60 days to remove my client from that vehicle. My client will maintain sole possession of the marital home during the pendency of the divorce, which means my client is responsible for the debts associated with the house during the pendency of the divorce, just like Mom is responsible for the debt associated with the automobile during the pendency of the divorce. The parties have agreed to hold each other harmless for any liability they incur individually since the date of separation. And the parties agree that they will each maintain medical cards for the benefit of the minor child that they share in common. The parties have agreed to keep all of their payments current for any assets in their possession, including but not limited to automobiles, real estate, credit cards, and loans. In my discussion with the parties, they don't believe they have joint credit card debt, Judge, but they're both going to check and advise, and we can resolve that issue later. And neither party will conceal, destroy, transfer, encumber, assign, or otherwise dispose of each other's assets. The two issues, Judge, that we need some direction from the court. The defendant has an incredibly large dog who goes through a significant amount of food and sheds. And my client has no desire to keep this dog. The defendant would like my client ordered to keep the dog until she's ready to take him. My client has advised that's not an option.
You want to repeat that?
The defendant would like my client to keep a dog,
Oh, I see. Okay.
until the divorce or until she's ready to take possession. We would ask the court to order her to retrieve the dog today. It's not my client's dog. He doesn't want it. He doesn't want to pay for it. It's like the size of a small horse. So we would ask the court to order her to take the dog today, and we'll make arrangements to have the dog available to her. The other issue we have, Judge, is specifically a temporary order for parenting time, which we need to have in place so this child knows where he is, where he's supposed to be, and who he's supposed to be with. Our proposal is that Mom take alternating weekends. I don't believe we'll still be doing this in summer, but if we are in summer, we can address that. But alternating weekends, Friday when school releases, or at 9 a.m. if there's no school, until Monday when she drops the child off, or if there's no school when she drops the child off at 9 a.m. Mom is doing the transportation because Mom moved out of the area, and she's agreed to continue to do that. My client has agreed with that. Mom would like week on, week off. The issue we have with week on, week off is Mom will often say, I want to take him for a week, I'm going to pick him up. And then 2 or 3 days into having him, my client gets him back, and he loves having his child. He has no issue with that. But then he has to change his work schedule. And so the child needs consistency, and that's reflective of what she's actually exercising in time. And it allows the child to have the consistency in his home where he's lived, where he's accustomed, by his school, his minutes from school. So we would ask at least for a temporary fashion, the court order alternating weekends for her. 9 a.m. if there's no school on Friday, or after school Friday until the child goes to school on Monday, and if there's no school until 9 a.m. on Monday, until we have another order agreement. I do think Judge will be able to come up with an agreement as we go forward.
How old's the child?
He's 8. Oh, 6, I'm sorry. He's 6, I'm sorry, Judge. Thinking of the other case.
And Dad lives in what town?
Dad lives in Harbor Beach where the child resides and goes to school.
Mom?
Apparently lives in Kenya now.
Okay. All right, would you please inquire of Ms. Cazzetto regarding what's agreed to?
Did you say Ms. or Mr.?
Ms.
Yes. Ma'am, did you hear the settlement that I placed on the record with regards to the items that you all have agreed to?
Yes, but I did not agree to one of them.
Okay, go ahead and tell the court.
The significant other and opposite sex one, I did not agree to that one because we both have significant others that the child does have bonds with and does stay the night with, as well as our significant others' children as well.
I'm happy to address that, Judge. I thought she did agree to it, whether she agrees to it or not. I think it would be appropriate. She's in a very new relationship that started sometime in August. And the child is already going to be confused that now there's a new dad in the picture.
Are there any issues regarding this individual, regarding criminal backgrounds, anything like that?
We know that his brother is a multiple convicted felon. We know that his brother's significant other came as her support person today and she has regular contact. I don't know her significant other because frankly, we didn't know where she was. The deputy had to find her. So she's not been forthcoming about where she is. She's not forthcoming about who she's with, but we know who she associates with. And it's the brother of her current boyfriend, and that's a concern for us.
He's known where I've been. He's met me before to get Carter and has watched where he's literally followed me from Caseville.
What's the name of the individual that?
Jacob Butterfield. And
that is your.
that is my boyfriend, yes.
Okay.
And yes, my child does, he even knows, does have fun with him. Anytime I talk to our son on the phone, on FaceTime or anything, he's automatically asking, what's Jake doing? What's, his son doing? Automatically, he tells him stuff about what we go and do, as well as he tells me about stuff they go and do. Because he as well has a bond with who he has, I don't know if they are dating, whatever, that's none of my business, as well as has a bond with her, which I am fine with. He is aware, he has a dad. That is not whatsoever no, that's not the case at all. It's not another dad or anything like that. And he knows that. I've talked to him about that. So,
To be clear, Judge.
Just a moment, I'm going to ask. Well, the court takes judicial notice of its own records. I believe Mr. Butterfield is the same individual that was before me back in 15.
I would believe that's correct, Judge. Jared Butterfield.
That's the brother.
Yes, that's correct, Judge. Okay. And I would agree that he was in front of you sometime at that point. I'm looking at the Otis records.
Right.
And
So-
all crimes of violence.
Without mentioning the child's name, is the brother.
he's never around us. He drives for a trucking company and I don't ever see him. I work with his significant other. So I've known her for years before this even happened.
How long have you known Jacob Butterfield?
I've known Jacob.
Or how long have you been dating, I should say?
Since beginning of August, we have been with each other.
Okay.
But Brandon does know him and his brother and has had him and his brother both at our house before when we were still married.
Regarding everything else that was mentioned, you agree with that?
With,
What was mentioned by Ms. Rogenbuck regarding what the parties agree? You said there's one thing you don't agree with.
yes, besides the other two things that we couldn't come to an agreement on, yes.
All right, and you feel that otherwise what's agreed to is in the best interest of the minor child?
Yes.
Anything else?
I would inquire of my client, Judge.
Yes,
On
I'm
the
going to
record.
allow you to do so.
Yep. Mr. Kazaka, did you hear the settlement I placed on the record?
Yes, sir.
Did you understand the terms of the settlement placed on the record? You understand that this is temporary, this is not your judgment of divorce, the front of the court's gonna do some work?
Yep.
Okay, do you agree that the settlement placed on the record is in the best interest of your minor child? You heard Ms. Kazaka say she doesn't agree to having non-relative opposite sex people in the presence of the minor child. Do you have a current girlfriend that is living with you?
I have a girlfriend. I have a friend, yes, that's involved and sees my son, yes.
Okay, and does she see your son? Tell me how she has a relationship with your son. What's the connection between her and your son?
Friend?
Okay, and does she have a child the age of your child?
Yes,
And
they're
do those-
best friends.
Do those children go to school together?
Yes, they see each other and play every day.
Okay, and is that the connection between the alleged girlfriend and your child?
Yes,
Okay, are you comfortable with having no non-relative opposite sex people in the presence of your minor child for both of you? You agree it should be for both of you, is that correct?
that is best, yes.
Okay, and you understand that's not forever, that's just during the pendency of this case? Okay, and you heard the settlement, the statement I placed on the record about parenting time alternating weekends for mom, 9 a.m. If there's no school, after school until drop off on Monday, if there is no school till 9 a.m. on Monday?
Yes.
Okay, and you agree that that's in the best interest of your child? And do you want to keep your ex-wife's dog?
Absolutely not,
Okay, would you like her to take possession of it today?
absolutely.
Okay. Judge, I have nothing else at this time.
All right, let's go back to the dog now. You have any comment regarding?
I have to get one of the invisible fence collar chargers for him. And I told Brandon that I would supply the food for him and everything until I get them. They are expensive collars. They're not cheap collars. They're like $500. So I did ask at least 30 days so that I can get the collar. Yes, it is my dog. I had it before we were together. He's almost 9 years old and our son's 6. So it's as well as his dog too. So right now, I don't have the collar, so I can't take him there at the moment. I don't have a fence in ours. And
Can you keep the animal in the house?
not go outside at all?
Well, I
No.
mean, if you take the animal outside for the animal to do the things the animal needs to do on a leash,
I would have to talk to the landlord if the dog can be inside, because as of right now, he would be like an outside dog, but he loves being outside.
what about this issue of working 40 hours?
So I work at here on medical center, and I work Monday through Sunday, 12-hour shifts on the weeks, because we were doing week on, week off. And on days that, you know, if I would text him and ask him to, you know, it would be Carter would want to come home, or he, you know.
Well, no, I'm asking about working 40 hours.
Right, so I would work Monday through Sunday, 12-hour days, and then the weeks that I had Carter, I wouldn't work because I can make my own schedule. Their full time is only 32 hours a week.
All right,
So
but you're able to buy.
if I needed, yes, I could pick up, but I don't want to physically and mentally drain myself. I'm already working 12-hour days, Monday through Sunday.
Sure.
So, I mean, can I work 16-hour shifts every day? Yes. Do I want to mentally and physically drain myself? No, because I've done that at my previous job. And
What is your, I know where you work, but what?
I'm a CNO.
Okay,
So, I mean, it's not, it's, it's draining.
all right. Okay. And you wish to go alternate weeks, week on, week off?
Yes, which is what we've been doing, and our son has expressed to both of us that.
I'm not gonna go into what the
object.
child may have said. My question is, child's going to Harbor Beach schools?
Mhm.
Is that a yes?
Yes,
How does the child get up in the morning to get to Harbor Beach, get picked up, brought back?
I take him every day and pick him up every day.
Okay. All right, thank you. I'm ready to make a ruling on that. Regarding what's agreed to, the court accepts the agreement of the parties, and that will be presented to the court in an order presented by Ms. Rogenbach. So, joint legal custody, temporary sole physical custody in front of the court, referral regarding child custody support, everything, the whole 9 yards. This is an initial determination. Proof of residence, parenting, etc. Regarding the parenting in this matter, the child is 6 years of age. It appears at one point it was sort of week on, week off. And now the request is alternate weekends, and mother wishes to have essentially equal time. I don't have a lot to go on at this point, because this is an initial determination. There was allegations regarding where mother is living. Here's now we may have that information closed, but at this point, the court is going to order on an interim basis, not alternate weekends, but 3 weekends per month. Friday at 6, Sunday at 6 for mother. This will not establish a custodial environment. And the reason for that is because the court wants to have fairness across the board for all parties relative to how we move forward in this case. Relative to the dog, and I'm not going to lie, I'm a dog lover. I have dogs at home, my children have dogs, my court staff has dogs, my friends have dogs, I get it. Father currently has the animal. Mom does not. She admits it's her dog. She's offering payment of food and all of that. And I did inquire if proper payment is made to father just for 30 days, would they be willing to hold on to the dog for 30 days if there's payment?
We actually had the conversation, Judge. The problem is she's been gone since July and has always been going to do that and hasn't. So my client is feeding a monstrosity of a dog that's not his, that he doesn't want, that he can't afford to feed.
How much does it cost per month for the dog? Or how much per month to feed the dog?
Month, at minimum $100.
At a minimum?
Yes, 25 a week.
What size, what type of dog is this?
An Anatolian Shepherd.
A what?
An Anatolian Shepherd. It's not a $100 a month to feed that dog. Maybe both dogs. Because he has his own, but not him.
Do you want the dog back? Want the dog back?
I do, but I can't, I have to get that collar.
Either $75, well, strike that, I'm going $80. $80 needs to be supplied to the plaintiff by the end of business today to take care of the animal expenses for 30 days. If it's not, the animals be returned to month. So she has to pay $80 today. If she doesn't pay it by the close of business today, the animals return to mother. It's your responsibility.
2 questions about that, Judge, so I have this correct in the order. She has to pay my client $80 by the end of business today.
Yes.
So we'll treat that as 5 p.m. so everybody knows the correct time.
Very good.
He's responsible then to keep it for 30 days. At the end of 30 days, what happens? Because
The animals return to mother.
and if she doesn't pay him, and how should he return it, Judge?
That she has to make arrangements to pick up a child or a child. It's not, it can be, I can understand that. My doggies can be children too at days. She has to pick up the dog at 6 p.m. If the animal is not picked up at 6 p.m., father has the right, and I don't want to do this, to contact some area shelters for the pet. I don't want to do that, but we need to address it now.
Okay, Judge, so to be clear, she has to pay at 80 by the close of business today. And we should probably do 6 o'clock because that's when her parenting time starts, so she doesn't have to sit around.
That's fine.
And if she doesn't make arrangements within 30 days to retrieve the dog, or she doesn't make payment, the dog can go to the animal shelter.
Correct.
Okay,
The weekends will be the first, second, and fourth weekends of each month. Regarding the 40 hours and that's for an interim support, it appears to the court clearly that mom is able-bodied. Her job may have different scheduling relative to hours in this matter, but actually, let me ask Ms. Schultz on that. I'm hearing information that her work schedule is 32 hours per week. Are you familiar with that in the medical field?
Generally speaking, a lot of the medical providers have went to a work schedule which is less than 40 hours. Most fall between 30 and 37 and a half.
I'm not going to find 40, but I'm going to find 32 hours per week.
thank you, Judge.
Trying to be fair. Let's see, what else?
I think the only other thing, Judge, is the non-relative opposite sex.
Oh, yes, non-relative. The court has heard the arguments of counsel and the party relative to this. And I understand the issues of the significant other's brother. I get that, I understand that. But I'm not hearing anything specifically regarding this particular individual. Now, if there was any potential harm to the child, this would be a different story. I'm not going to work, in this case, the non-relative. However, the non-relatives, whether it be dad's significant other or mom's significant other, they need to be told, don't confuse this child. That's number one. This child has a mother, this child has a father, and that's the way it should be. Supporting people are one thing, but to raise them up to a higher level can be extremely confusing to a 6-year-old. That's we don't need. So I'm not ordering that at this point.
Judge, I just want to be clear so that there's no confusion on either party. You're not ordering non-relative opposite sex, but the parties did agree, no felons, parolees, probationers.
Oh, absolutely.
Okay, and I just want the parties to be clear on that.
Safety of the child. Does that cover all the matters?
I believe so, Judge.
This? That'll be all. Thank
I'll
you.
submit it on the 7-day.
Sounds good.
Thank you.
Motion regarding support. Parties are present. Would you both please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God? Yes.
Yes. Okay, thank you. This is Ms. Crone's motion regarding support. As I understand it, in front of the court, correct me if I'm wrong, father is, for purpose of support, is identified as having 9 overnights. Is that still the story?
Yes, Your Honor. The friend of the court had received a referral from the court to conduct a review of child support. That process was completed and the order entered August 16th. And credit was given for 90 overnights, which is what is in the current parenting tax order. Subsequently, Ms. Crone filed this motion because she has alleged that Mr. Haley is not exercising those overnights, and would like the court to address that.
All right, thank you. Is that the story, Ms. Crone?
Correct.
How many overnights do you believe Mr. Haley has been exercising with the child?
Maybe 3 during hunting season.
How long has this been going on?
2020 maybe.
Have you ever filed a motion like this before?
No.
Okay. And you believe that support should change because you are taking a bulwark of all the overnights?
Correct.
I see. Mr. Haley, how do you respond to this?
Well, as of January into February, he was with me both those months. And,
Okay, I'll give you 60.
okay, and then I asked him to come over, stay the night, he don't want to. Why, I don't know.
The child doesn't want to?
Yes.
Okay. How
I mean, I can't make him go.
old is the child?
15.
And you said you had the child January and February of this year? Is that the whole time?
Pretty close, yeah.
What was the situation there? Because what is the original parenting time schedule?
50-50. It used to be 50-50, and then we went back for child support because he wasn't helping with anything, and then the questionnaire asked how many days, and that's why we're here today. But since it's been 50-50 in 2019, Alan really hasn't been there saying that.
Okay, so is it, as the parties mutually agree regarding parenting time then, or is it still week on, week off? Confused.
Neutral as far as I know.
It's mutual 50-50, but Alan just doesn't want to go over there.
You encourage the child to go?
Yeah.
Mr. Haley, do you have any other comment?
No, I mean, I can't make him come. I mean, I don't know.
Do you encourage him?
Oh, yeah.
Do you have any idea why the child may not be interested?
I had no idea. No. I
Do you have
not.
any mutual interest?
So I, what?
Any mutual interest? I'm sorry, I'm
Yeah.
completely stuffed up. The ragweed weed is going full force right now.
Yeah, we do. I mean, like weekly stuff, we do stuff. I mean, we hang out and do stuff, whatever.
Is the child involved in sports?
Not anymore.
He's homeschooled.
Okay. What about hunting, fishing?
Oh, yeah. Oh, yeah.
So when it comes your time to have the child, why not show up with hip boots, a fishing rod and reel?
We do. I just took one on the youth hunt 2 weeks ago. We went.
Okay. Well, I could speak with the child, but I don't think that's going to make any difference at this point. The issue is that it's alleged that the child spends much more time with mom rather than dad. He's 15 years of age. Father does state though January and February, there was a significant amount of time. They were overnights too, correct? Overnights that the child has been with dad. These are tough cases because when it comes to children who get a little bit older, a lot of people think that once they get a certain age, they have the right to make their own decisions relative to who they stay with, or when they get a certain age, whatever the child's preference is. That's not the law. Never has been the law. The law simply is whatever the schedule is the schedule that the parents are to follow, and it's enforceable against the parents and not the child. So that's kind of a problem because the parents can talk till they're blue in the face saying, you need to go to dad or you need to go to mom, but they just don't want to go. It doesn't appear to the court that Mr. Haley is trying to avoid spending time with the child. It's a matter of the child's preference, which unfortunately is not a good situation, because if you have two fit parents, the child should have bonds with both parents, the child. And it just helps that child move even further. I don't find proper cause or change in circumstance in this matter to Ms. Brown, so I have to deny your motion. However, I will tell you this to Mr. Haley. It's tough. It's very tough when a bulwark of the time is with the other parent and the other, and you, the parent who doesn't have the child. That's a potential financial savings. I would highly suggest that you sit down with mom and try and figure out something, whether it is, you agree to pay for a youth hunt or something that would help kind of alleviate some of these extra expenses.
Yep. I did just buy him a new bow and stuff, so.
Well,
I mean,
a new bow
I
is
know,
one thing,
it's
but
besides the point.
that doesn't put food in the child's mouth, clothing, extracurricular activities, that sort of thing. I saw a hand raised in the back, but Mr. Cron, you're not a party to the action, so unfortunately I can't speak with you. No disrespect, but that is my ruling. Mr. Haley, sharpen your pencil here a little bit and talk to mom about some of these things to alleviate some of these expenses. If it were simply you saying, I just don't want to spend time with the child, I'm going to tell you, Ms. Cronin, if that were the case, we'd have a different discussion, but we're not.
We still pay for everything for his hunting besides his bow. We pay for his fishing, we pay for his hunting clothes, his boots. We still pay for everything.
How much?
His hunting license was just 40 for the youth hunt.
Okay.
His fishing license, I don't know how much that was. He did get him his duck stamp. We bought him his duck and goose hunting license.
Well, we have 40 so far. How much more do you have?
I don't know how much it was altogether. But the only thing that he did buy him was that
Duck stick.
his duck stamp and his bow.
Okay.
Like we buy his bullets, we buy his gun, we buy.
So his
everything.
interest is hunting, correct?
Correct, and fishing.
Okay.
But more hunting.
Dad?
You don't need a small or a goose license until you're 16.
Oh, Dad.
I'm just saying it's free, I know, I did buy the stamp. It is, you don't need one until he's 16, it's right in the book.
Dan,
I was there to buy
I
it,
can
yes.
see where the potential issue is now. Dan, you got to step up here a little bit. Just being respectful here. Talk to mom, $40 for this, $50 for that, it does all add up.
Yeah.
And would you be willing to at least give her some money relative to these hunting and fishing expenses?
I'm not worried about that. I was just like, the whole, he doesn't stay there 90 days.
I addressed that.
I know.
Ms. Cronin. I'm trying to be fair here, trying to come up with something other than what you stated, because I can't find proper cause for change in circumstance. So I'm just going to leave it at this, Mr. Haley. You need to talk to Ms. Cronin and talk with her regarding some of these added expenses. And to be honest with you, if it does continue, and it's a matter that I have to speak with the child comes back and I speak with the child with the pregnant report, and it's not a matter of, well, let me just put it this way. I speak with the child, the motion comes before the court, and if there's a finding that it's not a matter of not wanting to be with dad or something else along that line, the court can modify support. It can be rather drastic. When you go from 90 days down to 3 overnights, the support amount could be rather high. So I'm putting you on notice. That also means this: if he doesn't want to show or be with you, you've got to find some ways to be creative to get him interested. That's your responsibility. But if it comes back before the court, Ms. Cronin, my decision could change. Okay? Good luck to both. This is Ms. Lee Seward's motion. Seward's motion. Anna Lee is hyphenated. She's in the courtroom. Court calls Timothy R. Fritz. Timothy R. Fritz. No response. The court did check Zoom as well. No one checking in by that name. There's a proof of service here as well, dated September 13, 2024. So service is proper. Ms. Seaworth, would you please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Thank you. Please state your name.
Annalise Stewart.
Ms. Seaworth, what are you requesting from the board? Obviously regarding tax exemptions.
Well, in the original divorce decree, we could claim her every other year. We claimed her on the evens and I claimed her on the odds. I like that revoked, so I no longer claim her. Now that he lives out of state, obviously financial burden is gonna fall more on me.
Is
He
he
doesn't
paying,
take her his overnight or anything like that.
how many overnights is he awarded?
Whatever the front of the court has awarded him, which he never took her that many anyway.
Do you have any idea how many overnights are?
The current overnights are 90 pursuant to the 1997 front of the court guidelines. However, if we were to look at the long distance policy, that would be credit for 7. If
And you're stating that father has not had these overnights. How many overnights has he been involved?
Since the divorce, the most he's ever taken her is like 70 something. And
Per
it got
year?
less. Yeah, per year.
Per year.
And it got less after that. Like the last time I can remember was like 30 overnights. I mean, granted, as she got older, she didn't want to go either, but
All right, thank you. This one's a little bit different than the last one, and I'll explain why. Father sounds like he is exercising some time, but here at the best with his current location and the long distance policy, 70 overnights would be more proper than the circumstances. The tax exemption issue is a little bit different, and I'll explain why. It's something that's agreed to between the parties, and it's binding in the judgment, and the court rarely, if ever, will modify that absent some sort of circumstance that's rather significant. And just like the last hearing, sometimes parents don't spend the overnights that they're supposed to be spending with their children. That's unfortunate because that's quality time you can have with your child that the party's not executing. I can't modify the income tax exemption because that's what was agreed to in the judgment, and the judgment is the judgment. However, in this case, which is different than the other, father lives in New York, he does exercise parenting time, but not to the extent of 90 days. The court is going to modify support finding a change in circumstance. That is, the father is not executing the time as required and will modify the support amount to reflect 7 overnights, not 90. So the support amount is going to go up. I don't know how much it's going to go up, but clearly it's going to change. So Schultz, can you reflect that?
there is currently a review of child support that was requested by Ms. Seward, and so we will issue that calculation based on 70 overnight when the process is complete.
Great. Any questions? No. Good luck to you. Thank you. Mr. St. John's motion regarding parenting time. He appears by the Zoom application. Ms. Camacho appears in the courtroom. Would you both please raise your right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God? Yeah.
I do. Yes.
Can we get to the front of the court, please?
Your Honor, in this cause of action, an order was entered regarding parenting time on November 7th of 2022. That order granted the parties joint legal custody as well as joint physical custody and awarded Ms. Camacho parenting time on alternate weekends, Friday at 6 until Sunday at 5 p.m., as well as holidays pursuant to the 97 Huron County Front of the Court parenting time guidelines. However, there is a companion family division file that impacts the child at issue in this cause of action.
And there is a provision in there regarding the status of this child in that file. Right.
There have been no orders entered on the FOC side to reflect what's going on in the companion file.
I see.
My understanding is there is no parenting time for the companion file, but I'll refer to the court to review this reference.
Mr. St. John, I don't want to delve into the other file, but relative to the other file, just very limited. What is the parenting time, as you understand it, regarding mother?
Parenting time has been suspended for, I think 3 months now.
Okay, so that's all I need to hear. I'll get to Ms. Camacho in just a moment, but what are you requesting? I don't, it sounds like you wish to have her rights terminated. Is that correct? That's
Yes.
what,
I mean, not ideally, but yes, the chaos that all this has brought and, Andrea not being, beneficial to Peyton in the last, I'm sorry, my daughter.
thank you.
I've had my daughter for 3 years straight, and the communication between her and her mother is non-existent. And when it was just horrible, just very negative, and and nothing's changing. It's just a very toxic environment, and like this month, there's been no communication. I believe Andrea has either blocked my daughter or unfriended her, so my daughter doesn't see her mother's day to day anymore. And now her grades are up, and like she just missed honor roll by a C plus. She's all A's and B's now. And last year it was chaos. I've been helping, and I'm in class myself for my builder's license. And we're just not getting any support from her side. Actually, she did finally catch up on her child support, but that was non-existent. Birthdays.
Well, this is regarding parenting time is what I'm saying. This is
Yes,
regarding parenting support. Okay, I think I understand what you're saying. Ms. Camacho, is there anything you'd like to say?
Yeah, regarding his motion, he sounds uneducated a little bit, probably going to school and getting his builder's license. He wants to talk about a lot of stuff with me not being able to be in my daughter's life when there's the other case that's been going on. So it's kind of hard because I'm not able to be in her life. So how am I supposed to engage in her life and have any type of communication with her when most of the time it's monitored by Mr. St. John, and he's the one that is toxic because him and I cannot get along.
I see. Okay. All right, well, there's a companion case. The court takes judicial notice of its own records. And at this point in time, because I did read the motion, and the motion in part was essentially Mr. St. John requesting that simply mom's rights be terminated. That's not in this type of proceeding. It could be in another, but not in this type of proceeding. Simply put, the court is going to order in this case that whatever is ordered regarding parenting time in the companion file applies to this file. And that's how we leave it.
I guess I don't understand.
That means parenting time is suspended.
Right,
in this
right.
file.
Okay.
And whatever happens in the other file clearly will probably have bearing on what happens in this file moving forward as well. I don't know where that other file is going at this point. However, I hope it goes in the best interest of the child regardless and to all parties involved. So parenting time is suspended because that is the order currently in the other file. And when I say parenting time suspended, all I'm saying is whatever orders are in the other file apply to this file. So if something changes in the other file, it'll change in this file as well.
Yes, and I will make sure the order reflects that, Your Honor. I appreciate the court explaining that to the parties, that will be a moving order under the front of the court file.
Correct. That'll be all. Thank you, everyone. Show cause hearing regarding allegations pertaining to Mr. Raven. Court calls James A. Raven Jr. No response. Court did look at the Zoom screen. No one is checked in by that name. There's one individual checked in, however, it is not Mr. Raven. The court is in receipt of an order for show cause requiring Mr. Raven to be present before the court today to be heard regarding establishing a payment plan and or to be found in contempt for failing to make payments. Mr. Holt, would you have this file, sir?
I do, Your Honor. Mr. Raven has been set for continuous show causes with our office, at which he shows up for those hearings, states to the front of the court office that he's gained employment. We send verification of the employment, start withholding wages, and then we are informed by the employer that he either quit or was not at that facility. It is my understanding that Mr. Raven is scheduled for an AG sentencing hearing this upcoming Monday. Will failure to appear today for this show cause. This is a continuance. There's been no payments on this account since January of this year. There was a $200 payment, I do believe. And then in February, there was a $4,400 bond payment that was applied as a result of the criminal file. So both were not necessarily willful payments for Mr. Raven. There's been zero effort to pay even a penny on this case. And with them not showing up today for today's show cause hearing, I'd ask that a warrant issue with a $6,300 bond. With roughly 25% of the arrears.
Again, James A. Raven Jr. No response. Raven has failed to appear. Notice has been properly provided to Mr. Raven to appear in court today. The court does take judicial notice of its own records indicating that the defendant is scheduled to be before this court on Monday. Regardless, the court is issuing a bench warrant for his arrest, and the amount of bond in this matter will be $6,300. You'll prepare that. Thank you. Time of day set for show cause hearing. Rio is present. Show cause hearing is requested regarding allegations pertaining to him. Actually, not allegations. I believe the show cause is scheduled for today for purposes of determining ability to earn income, as well as potentially setting up a quarter repayment plan. Mr. Rio, would you please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
You understand?
Your Honor, court is correct. There was a show cause hearing held on July 31st within the front of the court office, at which time the plaintiff had appeared. At that time, a $50 payment was made, and the show cause was adjourned to today's hearing to establish a payment plan and take testimony from the plaintiff as to his ability to earn income. For the month of September, so far, at least from the system, there's been $200 that was paid. I do believe another $100 was paid today, and there may be an additional $100 that was paid earlier this month that hasn't posted yet. It is charging $430 per month, and at this time, Your Honor, the account is $2,124.90 in arrears.
All right, thank you. And I believe the show cause is requesting information, sworn testimony relative to ability to earn.
Correct. I believe odd jobs have been done. There's some woodworking they make on the side and sell. So I'm asking that testimony be taken for that to be further detailed as to his ability to earn, as well as to establish a payment plan that he can stick to. And if he fails to follow that payment plan, then
Mr. Rio, did you hear all that, sir? Yeah. Okay, and you're sworn, sir. So you're in woodworking?
Yeah, I was making chicken coops and deer blinds and dog houses and stuff like that.
Good. And is that your only source of income?
No, and then I work at my family kennel. I'm there 7 days a week, but it kind of depends on how many dogs I'm training or how many puppies we have for how much money I make.
All right, so what kind of puppies are we talking about here?
Labs, Brittany's, and German Shorthairs.
Okay, so we're talking large animals.
Yeah, hunting dogs.
Hunting dogs, absolutely. And that takes a lot of physical and mental work, doesn't it?
7 days a week.
Okay. So is there anything preventing you from other sources of employment that is a guaranteed income? In other words, you're guaranteed to have X amount of dollars per hour.
Besides that, I'm working there almost all day.
Right, but there's nothing stopping you from looking at other employment that have more of a steady income. Do you agree?
Yeah, I guess so.
Okay. I mean, there's nothing preventing you from filing applications at, doesn't matter whether it be restaurants, factories, courthouses, anything like that, right?
I decided I'm trying to take over my family kennel.
Okay. So
My dad's planning on retiring.
how would you be able to take over the family kennel without significant income?
But when he retires, I will.
Well, when's he intend to retire?
Not sure when he plans on it, but
2 years, 5 years, 20 years? Any idea?
well, he's 63, but so probably a couple of years.
Okay. But, and the court cannot order this, but if the court could order this, that you need to apply to a factory that works 40 hours a week. There's nothing physically or mentally stopping you from having a position like that, correct?
Yeah, I guess.
There is?
Well, no.
Okay, that's what I'm just trying to understand. And I'm not trying to trick you here, sir. I'm just trying to get an understanding. With your woodworking, how much per month do you believe you receive per month in that position?
It's hard to say. Now it depends on how much I sell. During the spring, I was selling chicken coops and I sold like 10 of them for $400 a piece. Then it kind of died down and no one was buying them. And then I was selling deer blinds and I think I'm on like 12 of them.
For how much?
$400. No, but I'm guessing after November, I'm not gonna be able to sell very many deer blinds.
What about the kennel? Do you make any, and then the training, how much do you make per animal?
I get a couple $100, $300 per dog I train. And well, this summer it's kind of been slow. Right now I have 4 dogs in for training and one's coming this weekend.
And that'd be $300 a day.
$300 a dog per month.
Okay, $300 per dog, sorry. So if you had to guesstimate per year, how much do you think last year? You were in this business last year as well, correct?
Yeah,
How
I was
much
trying to
last
get
year?
a tree cutting job, starting my own tree company, but my employee quit, my truck broke, and I haven't got really many jobs from that, so.
Okay, but back to the animal training. Can you give me a ballpark per year, how much you made last year?
I think it was about 20,000.
20,000?
Yeah.
Okay. Can you give me a ballpark last year for chicken coops, deer blinds that you may have made last year?
Oh, seven or 8,000.
Let's talk about payment plans. 21, 24 is what's behind right now. What can you do in monthly payments?
Bucks a week.
50 a week?
Yeah.
Beginning when?
And now,
Beginning Monday?
Yeah.
Actually, it'd be better getting October 1 Tuesday.
That's what the court decides. Like I said, there were some months of September already paid.
Okay.
Just looking at it roughly, Your Honor, if he paid anywhere between $100 and $120 a week, he would meet his monthly obligation.
So the best you're saying is 50.
I know I can do 50, I might be able to do better than that, but depends on, the week.
Let's do this. Do you give, is there anything, Mr. Holbrook, you need relative to the ability to pay more than what I've asked?
No, Your Honor.
Okay. All right, this is what we'll do. If it's $50 a week, now if it were $125 a week, that would catch up your arrearage. Let's go beginning, we'll just do September 30th by Monday. By Monday, $50 each week, each Monday. If you can pay more, I strongly encourage it because the Attorney General's office looks at these cases all the time.
Okay.
And do a review in 60 days to see how we're doing. Is that acceptable to you, Mr. Holbrook?
Yes, is the 60-day review, does the court wish to have that on Friday?
Yes, we'll do it on Friday, right here. That work, all right. We'll get a date then. 60
And
days.
they'll send me something in the mail
We're going to give it to you right now.
right now, all right.
November 22nd.
November 22nd is what day?
Can you write down a sticky note for me?
We're going to give you notice.
Thank you.
We'll give you notice right now. That's a Friday. First payment has to be paid to the front of the court's office by the close of business Monday, $50 each week. Any questions?
No.
And again, if you can pay more, do so because you don't want to come back here in this court. All right, that'll be all. That covered this role?
Just for the record, Your Honor, that $50 a week on a minimum isn't even going to be his monthly obligation. His arrears will continue to grow.
So that means you need to step it up.
All right,
Now, you may need to think about other employment because I find that you are able-bodied.
all right.
And if you find something, and there are plenty of jobs out there, believe it or not, please take advantage of that. This is for your child.
Right.
That'll be all. This reporter's motion regarding custody. He's present, mother is present as well. This guy, both please raise your hand.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Something from the front of the court regarding this. My understanding is that parenting time was suspended. Court had ordered that. What's the status now?
Just for background on this file, Your Honor, on September 26th of 2023, the Graham Travers friend of the court office initiated a transfer of this case to Huron County as neither party resided in Graham Travers. We subsequently received the file, initiated setup of our case, and Ms. Geyer had filed motions. The court heard those motions on December 22nd of 2023, and at that time, on an interim basis, granted sole legal and sole physical custody to mother until such time as Mr. Warner petitioned the court for a redetermination of that issue. The court also suspended parenting time, with the exception of talk time, until such time as that issue was petitioned to the court for further determination. At the time that that December motion was heard, Mr. Warner was incarcerated, but the court did leave it open, everything on an interim basis to bring it back for determination. Previously, Mr. Warner had sole legal and sole physical custody with supervised visitation to the guy.
Mr. Warner, what is the proper cause or change in circumstance that requires reviewing this matter regarding custody?
Well, I'm released from jail.
What were you lodged in the jail for?
I had assault and battery with a deadly weapon and assault and battery with motor vehicle.
It's a felony?
Yes, sir.
And what was the sentence?
It was time served and
How many days did you serve?
it was about 7 months.
7 months?
Yep.
And that wasn't at this time, correct?
No.
Okay. So you served, what, 210 days in the county jail there?
Yes.
Are you on probation now?
Yes,
How long is your probationary term?
2 years.
When were you released from the jail?
Well, see, I got released from jail in March, and then they sent me to Docket for 120 days, so it would have been July 10th when I got out. Yep.
And you have stable housing?
Yes, sir.
You filed this in September. I'm just curious why you didn't file it after you released from TriCap.
I actually faxed over my initial filing on September 24th. I have the actual fax receipt right here.
Well, actually, we have it here September 11th.
Oh, no, I'm sorry, I'm in July 24th.
Oh, July.
July 24th. I waited however many weeks, I didn't hear nothing back, so I ended up calling. They said they never received the fax. I'm not sure if I sent it to the wrong place or not, but shortly after that, I filed again and got it through.
Okay. So what are you requesting other than, I mean, you're asking for what form of custody? Legal and physical.
I actually, I just wanted to come here to try to get him back living with me. I raised him for 13 years with full custody with zero effort given from the other party.
So,
and
is the change in circumstance just simply the fact that you were released from the county jail?
Pretty much, yeah. Before I went to jail, I found out I was going to jail. I had contacted Vicky because I was already getting a hold of her prior to that about her seeing Jason, which was me reaching out to her because I was breaking up with my other kid's mom after 13 years being with her, and I wanted to get him out of the stressful situation. And so I reached out to her and asked her if she would take Jason while I went to jail and just kind of leave it at that. That way he was in a comfortable situation. He was happy with her. And that's all I was really worried about because that's where he chose he wanted to be. And when I finally went to jail, we were communicating. I was still calling Jason all the time. And that's when Traverse City ended up transferring everything over here.
I see. And you still live on the west side of the state, correct?
Yes. I've been actually at my new address. I just got a house, a 2-bedroom, 2 weeks ago.
And you let the front of the court know of your new address?
I did. I just changed my address this morning.
Ms. Geyer, how do you respond to this?
I mean, I don't want to deny him seeing our child because he needs both his parents, and that I see him as fair. I think he should stay in school here because he is pretty much straight A student since he's been here. It's only been a year. When he first came here, his IEPs were saying that his grade point averages were lower than that he had the math grade level of a 3rd grader. I have his IEPs with me. I did try to, I want to say, beginning of this month into August, I did reach out to Mr. Warner asking about setting up in front of one of the FOC representatives to communicate so we could talk and communicate on matters. I didn't say anything else. I wasn't mean or nothing. And I was returned with paragraphs of not so happy comments and kind of aggression. I presented it to Ms. Schultz and said I would like this added to our case. I think he's mad because I changed it out of Grand Traverse. I don't know. But I feel that the child's safety is here. He is in therapy. He has doctor's appointments regularly. We have an at-home therapist that comes over every week, talks to him, the whole family. He's in a trauma session right now, actually. He's phenomenally improved in a year, mentally and physically.
Can you explain to the court why originally in this case, father was given sole legal, sole physical to the child?
They deemed me unfit for a parent for hearsay. I tried presenting proof and the lawyer told me that this was the best that I was going to get.
So you agreed to this?
I was naive, Your Honor.
No, I'm asking, did you agree with
Oh, yes, I did, because I believed that was the best case that I was going to see my son. And then anytime I did see my son, they disappeared. I never knew where they were. They were moving in and out of state a couple times. I didn't know where anybody was. And then when I did get to see him, there was a time back in 2016, 17, I do believe, where him and his girlfriend with his other children.
Okay, we're well beyond that. I was just trying to figure out what happened.
Yes.
By the Honorable David, is it David Stowe?
Yes.
Okay. Child's what grade?
He is in 8th grade now.
And child's doing well in school?
Phenomenal. Straight A, B average.
Okay.
He's an FFA as well.
You have family here?
Yes. We have my mother. We have some other family out in the Elma area that we do go and visit. And then
You're originally from this area?
I'm originally from Oscoda, but I had moved out this way with family.
When?
Oh gosh, back in 2018, 2019. And then I've been living in my apartment for 6 years now as of April 11th of 2019.
Okay. So on an interim basis right now, it's sole legal, sole physical. How do you feel about legal custody regarding decision-making to this child, for this child?
Oh, I'm 100% okay with that.
With what?
With the legal.
Joint or sole?
Joint. I would like joint.
So decision-making would be equal between you and father?
That's what I would like, yes. I would like for
I'm
everything.
assuming dad would have no objection to that. Correct?
That's correct.
Okay. Do you think it's in the child's best interest that legal custody be joint? Yes.
Yeah.
Sir. Or will order joint legal custody. You're opposed to custody, physical custody with father, according to your words, correct?
Yes.
What are you proposing in the alternate?
I'm down with the weekends, every other holidays, just standard. I think it's the 2016 parenting time orders where it's like every other weekends and every other holiday,
When's the last time the child has seen father?
since his incarceration. So
How
I
long is
would,
that?
September 9th.
yes,
last
of
year.
last
So
year.
we're talking a year.
Yes.
Do you fear any issues of the child seeing father since it's been a little over a year?
No, I have no problems with that whatsoever.
Perfect. Okay.
Like I said, Your Honor, I believe that the child deserves both of his parents.
Appreciate that. Mr. Warner, any other comments?
I disagree with the physical. I would like him to come back and live with me. I have raised him for 13 years, regardless of our situation, and bouncing around. Rentals are not everywhere. We've had issues with that. I have 3 other kids. I've raised all 4 of them since she pretty much told me I could have them when she initially left. We moved over to Traverse City when I was awarded full custody of them because she kidnapped them from my mom before everything was set into custody, and that's what failed. As a matter of fact, I have the original custody order. When it was made, there's not been a motion filed against or for that order for 13 years, and the only time she has seen him is when I reached out to her, including this last time. Since I've been incarcerated, she has cut off all of his siblings he grew up around, his grandma he's grown up around, and she's made it utterly difficult for me and my kids to get a hold of him since I've been out. Our time has been limited. She told him he can't come over unless he has a cell phone that she was going to get issued from by a state phone, but there's already phone issued to the property or the house, the address, and so I don't see how that was going to happen. She denied me when I first got out. I asked if he'd come over just for a couple of days. I was going to bring him right back. She said he could only come over for the evening for my son's birthday, and his siblings miss him dearly. I mean, they were all raised together, raised in the same house, raised by the same 2 people. She has not made no effort to hardly even pay child support, which I've never even made a big deal of. And the reason that the case was still in Traverse City is because I didn't file no motions. I didn't care about the courts. I figured when she was ready, she was ready. And again, I have reached out to her every time she has seen him. It has not been the other way around. And so finally I got to a point where I stopped and I moved on with my life up until I started running through rough waters again and wanted him to be comfortable. And that's when I got a hold of her. She agreed to start visiting him, and he started going over there immediately, despite no motions being filed against this original order that was supervised visitations. And that's when we agreed upon him going over there while I was in jail. That was the only stipulation that was supposed to happen. It was only supposed to be while I was in jail. And while I was in jail, she initiated all this. The order got changed over. I gave her power of attorney just in case he had any medical issues. And I feel like my entire situation was taken advantage of, despite what we agreed upon.
Okay, I think I understand now. This is a motion regarding custody. There must be initial showing of proper cause or change in circumstance to warrant a review of the custody factors for the court to proceed. The information provided to the court indicates that there was a voluntary transfer, so to speak, of the custodial arrangement initially, based upon father reaching out to mother regarding his current state regarding criminal charges. Now, there has to be that, as I said, a change in circumstance, and there was a stipulation regarding changes, or I should say change of legal custody, and the court has addressed that. But as to physical custody in this matter, it appears that the change in circumstance, as alleged by father, is his release from the county jail. Now, normally, under normal circumstances, that I don't think is by preponderance of the evidence to be a change in circumstance. However, there's case law out there regarding parents who have had to give up their children, hand the child over to the other parent because of, for instance, controlled substance issues, mental health issues, that sort of thing. And the idea of that was, well, the parent is actually doing the right thing by reaching out to the other parent and doing that because it's for the benefit of the child. And you shouldn't punish the parent who's having the problem to not have a chance of getting an opportunity back regarding that particular issue. In this case, physical custody. So under the circumstances here, considering the case law, court finds that there's a change in circumstance because now, despite the fact, we're not talking mental health or physical issue. My father, he was charged with a criminal offense, actually felonies, of which he served 7 months in the county jail. Even went as far as setting up a power of attorney as well to the child. So I find a change in circumstance regarding physical custody. As a result of that, the court will order the front of the court to do an investigation regarding physical custody and parenting time, as well as support, filed for the date of the motion regarding the support. The parties are required to give in front of the court all information relative to current status, employment, anything you think is important must be submitted to the front of the court's office. In the meantime, however, there is joint legal custody, and the court is going to reinstate parenting time. Now, there is some distance here because we're talking Huron County and Grand Traverse County, I believe. That's that county you reside in?
I reside in Montcalm County.
Montcalm County.
Yep.
Mom is in Huron. So how many miles are we talking here?
108. It takes 2 hours and 35 minutes from my front door, which I actually left work at 3 o'clock this morning to be over here.
On an interim basis, the board is going to order parenting time for father, alternate weekends, alternate holidays, alternate weekends, Friday at 6, Sunday at 6, Friday, whatever the school, if there is no school. What time is it on Friday and Sunday? Still 6 on Sunday.
Whatever time the court orders, because our 2016 guidelines are not currently in place, except for orders that have already adopted them. Our 22 guidelines say the schedule that's best for the family. I don't know what Mr. Warner's work schedule is, and I think the court will need to do that.
Yeah, what is your work schedule, sir?
I do 12-hour shifts or swing shifts. 1 week I work 3 days on, 2 days off, then 2 days on, and then the next week it's the opposite. It's really hard to grasp a hold of, honestly.
Well, I'm going to order the alternate weekends on an interim basis. What would be the best time to begin that?
As soon as possible.
I mean,
As soon as
your
possible.
work schedule warrant allow this weekend,
That work.
6 p.m.?
6 p.m. tonight.
Yes. Or well, since you're here, I would require after school today. After school or 6 p.m. If there is no school. On an interim basis. Is that acceptable?
Yep.
Is that acceptable?
Yes, Your Honor.
Okay. What school district? Lakers?
Lakers, yes.
What time do they get out?
They release at 3 and he gets off the bus between 3:15 and 3:30.
Well, it might surprise when dad shows up at the school. Can we meet? Can the parties meet at the gas station after school today?
Which gas station?
It's going to be the one, not the one at the main light.
The Clark.
The car, I call it the gas station. So can you meet there at 3:30?
Yes, Your Honor, I can.
Sir, can you as well?
Yep.
Okay, the child.
And I'm sorry, that's in
Elton.
Elton.
Elton?
It's got the subway attached to it.
So head to the main light where Meyer is, turn left and go about 8 miles or so. That's Elton.
Okay.
Right on 142. Sundays, the child is to be back with mom at 6 p.m. Is there a meeting spot you can both agree to?
The arranged meeting spot that we had going on before I went to jail was, I do believe, Saginaw at Walmart.
Yes, the Saginaw Walmart.
Okay, you both know what that is?
Yes,
We were using it for a meeting spot before I was incarcerated.
correct.
Okay.
We had already had everything set up to communicate and share parenting time and everything despite anything going on.
Okay, so that'll be the meeting spot, and is that the meeting spot for pickup and drop off then?
Yeah.
Except for today, obviously, since you're already here.
Right.
And that order will continue as well as the alternate parenting time schedule. I should say the alternate holiday schedule. The current one, I believe.
And mother shall be parent A and father parent B.
Yes.
correct?
Yes.
Is it okay, Your Honor, if he goes with his dad for Christmas this year? Just since he spent Christmas with me last year?
I'm assuming Dad's not gonna have any objection to that.
Absolutely not.
Because that in order as well. And then we'll do a review. Should we schedule a date now, or should we wait until the recommendation comes up?
I would suggest waiting for the recommendation, Your Honor.
We'll do.
Is the court also ordering that the parties may participate in ADR services with the friend of the court if they wish?
Any problem with that?
What's ADR services?
Alternative dispute resolution. You just try to work it out with friend of the court's office.
Yeah.
Okay. Order that as well. Anything else, Michelle?
No, Your Honor.
Please keep the friend of the court notified of any change of address or employment. And we'll run with the schedule for the time being. Once the report comes out, either party has the opportunity to object to it, file the appropriate paperwork. If neither party objects to it, it becomes the order of the court. So make sure your updated address is with the friend of the court's office. Make sure you grab your packets as well at the friend of the court office before you leave today.
Okay.
You get to pick up your son today, or your child, and that's your son or daughter, 3:30. That's how we leave it. Motion to regarding custody support and parenting time. Both parties are present. Both please raise your right hand.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you. You may put your hands down. Update from the front of the court.
Your Honor, on June 21st of 2023, a stipulated order was entered. That order granted the parties joint legal and joint physical custody of the minor child B. And D was also ordered to continue to attend Unionville Seedling area schools. Ms. Marr was granted parenting time during the school year to be exercised 3 weekends each month, from Friday at 7 until Sunday at 6, as well as week-to-week parenting time during the summer break from school and alternate holidays pursuant to the 2016 kind of the parenting time guidelines. She does have motions pending before the court today for custody, parenting time, and child support, alleging an incident of physical abuse of the minor child.
And has the front of the court received anything from CPS?
I have not received any information from Child Protective Services.
All right, Ms. Meyer, what is the probable cause or change in circumstance warranting modification of custody?
Well, I was alleged, I was told by Mr. Tucker himself.
Okay, so that's not hearsay. Go ahead.
Okay, I got a call on September 4th from him saying, and excuse my language, that I slapped the shit out of our kid. And he refused to give me a picture of what had happened. He said he backhanded our kid. Refused to give me a picture of it.
When was this call made?
It was made on September 4th,
This
the
year?
morning of September 4th.
This year, correct?
Yes.
Okay,
And when I got off the phone with him, he had advised me that him and his wife were getting a divorce. I immediately called his wife and asked her what had happened.
okay, we can't go into what she said though. That's
Okay, okay, that's fine. Okay, I had went up to the school and I seen my son's face. I received a picture of my son's face first. I have the picture on my phone. I went to the school, I got my son, I asked the school why I was not contacted.
Wait a second. Is there a companion personal protection order?
Yes,
That, I've seen the picture. Okay, now I know, this was ringing a bell. Okay, go ahead.
yes. I went to the school, I asked them why I was not advised, like why they did not contact me or contact CPS. The principal advised me that he had not seen the child.
Okay, we can't talk about what.
Okay, that's fine. I'm sorry.
Is there some sort of criminal investigation going on?
There's a
regarding
police
this alleged-
report, a police investigation going on right now until, it's been handed over to the prosecuting attorney's office. There is a CPS, and I do have the letter from the CPS worker on my phone saying that there's a CPS investigation going on until October 4th. And that I am not the perpetrator.
I did read that as well.
My
Where's
son,
the child right now?
he is at school right now.
Which school?
He is at Beaverton Elementary
And
because
how long has he been with you at Beavers?
I switched him over. He started September 11th at Beaverton after the school had failed me on protecting my child.
All right, despite the court order saying the child must be at USA school.
I did, and I'm sorry for that. I was trying to protect my child. And I knew it was important for him to stay in school.
Okay, what are you alleging that father said specifically regarding slapping the blank out of our child?
He had backhanded our child.
Did he say why?
He did not say why. He said the child had gotten healthy with him. My son had stated what had happened, and his story has not changed. He had told I took him to the emergency room. He had told the emergency room by himself what happened, CPS worker by himself, and his story has never changed.
Okay.
So, I do believe my son on what happened.
And your son against how old?
He's 7.
7. And did the court authorize a personal protection?
CPS, I went to.
I'm not asking about CPS.
No, they did not. They told me to do what was best to protect my son.
No.
No, court did not ask me to do a PPO, no.
No. I'm asking, did the court authorize the personal protection?
What do you mean? I guess I don't.
Granted, did the court grant a personal protection?
No, you denied it.
Okay. Wait a minute. Did you file this next friend?
Yes,
Okay.
that was granted.
The personal protection order was granted.
No, the next of friend was granted.
Right.
The personal protection order was denied because of, I didn't put in exactly what I needed to put in there. I wasn't sure how to do it.
Want to be sure. Okay.
I went to the Gladwin courthouse the day after I got my son on the 5th, and they told me they could not do a PPO against a parent, biological parent, for a minor child. So I left it alone. Then CPS told me on the 11th, go through Huron County or Tuscola County where the incident happened, and you can get one. So that's when I filed with you guys, but it was denied because it was said that I waited too long to file it.
Right. Okay, now I remember. Okay,
Yeah.
hold on to that. Sir, how do you respond to this? And I have to caution you, because if there are criminal allegations out there, anything you say can and will be used against you in another proceeding. You understand that?
Yes.
How do you respond to this then? Understanding that. And if you don't wish to respond, I understand that as well.
As far as like anything with the CPS or anything else with the police investigation, I haven't heard anything. So as far as I know, there's nothing going on as far as at this point. So with everything that's going on, with obviously no concrete evidence of anything, with her switching his schools and trying to switch his psychiatrist and all that stuff, which is probably going to get brought up, his psychiatrist, his doctors and all that stuff, within the last 3 weeks, I feel is irrelevant to the situation of what's going on, because there's nothing that's concrete evidence of that gives her the right to do what she did.
Have you seen the photograph?
I have.
How do you respond to the photograph?
I feel horrible about it.
Okay, I'm not asking you to comment regarding what you may or may not have done. I'm just asking you what you thought of the photograph. So I appreciate the answer. So the parties are to have joint legal, joint physical, the child's to attend USA, correct?
Yes.
And you want that changed, at least the
Yes.
physical.
Yes, sir. Can I also say something else?
Well, it's your motion, go ahead.
On September 4th, I was at the emergency room when CPS worker contacted me and said she was at Mr. Tucker's house to see the child. And I advised her I was at the emergency room. So him saying that he does not know anything about this is completely not the truth.
This is a motion for custody. Parenting time there's been nothing from CPS to your office regarding suspending anyone's time, correct?
No, Your Honor, and quite frankly, we were also provided a copy of the picture. And had I received that request for suspension, I would have submitted a next party order.
All right. Court finds a change in circumstance, warranting review of the child custody factors. In this case, the change in circumstances involve allegations of physical abuse of the child, allegations of physical abuse of a minor child. As a result, the front of the court is to conduct an investigation regarding custody, parenting time, and support in this matter relative to prior orders in this case of June 21, 2023. At this point in time, the court finds that there is proper basis to, on an interim basis, modify the physical custody aspect of this and order sole physical custody to mother on an interim basis. Joint legal shall remain. The USA School District provision is modified temporarily at this point while the front of the court conducts their investigation. And as to parenting time in this matter, at this point, I'm suspending parenting time pending the investigation.
Can I say something?
Yes.
I am not opposed, I know you said suspend visiting, but I'm not opposed to supervised visits because I'm not trying to get his rights terminated or anything.
All right. Well,
And
who do you
I did-
recommend for supervised parenting time?
Yes, I did send him a text and say that he could have supervised visits of him.
Who would supervise?
I would, or my boyfriend would.
I disagree. I don't know if it's a good idea to have a boyfriend involved. You'd be willing to do that?
My boyfriend has been in his life for 4 years.
I understand, but you have to understand the dynamic here. Boyfriend and the father of your child.
Okay, what about my mother?
I have no problem with that. Do you have any problem with your mother, Supervisor? What's your mother's name?
Penny Mark?
All right. What do you propose regarding parenting time? Supervise how, at what frequency?
I would propose like me or my mother, like I said, every other weekend, every other Saturday.
Every other Saturday?
Yes.
From what time to what time?
I'm open to whatever his availability is. I understand he's a truck driver, so I'm not opposed to it.
Are you available on Saturdays?
I can make myself available.
Okay. I see one party lives in Unionville, the other in Beaverton. Where would be the meeting spot?
We can do McDonald's at Center, which was our original meeting place for.
Center Avenue, Bay City?
Yes.
Does that work for you, sir? What time on Saturday are you available? Either.
Like I said, I can make myself available at any time.
I can do the same thing.
What time then? Wish to start this? Noon?
Yeah, I just asked that it be next Saturday because he has an event this Saturday.
That's fine. Noon until what?
Can we start out noon to 3 just because it's gonna be a change for him?
Any objection? Noon to 3, beginning next Saturday. Parties are to meet at McDonald's at Center Avenue in Essexville. And that'll begin next Saturday, beginning again from 12 noon until 3 p.m. It's to be supervised by either mother or Penny Mar, the maternal grandmother.
Okay, can I add something else just really quick?
Why not?
He still sees the same psychiatrist and therapist,
Who
like,
sees the child?
yeah, my child still sees Carol, psychiatrist and therapist. Like he said, I changed it. I was in the process of changing it because they told me I had to because he was staying with me, but he still sees the same one. The only thing I have changed is he has a home-based therapist that comes to the house to see him week on week, like comes to the house 1 week, goes to the school the next week, because I felt it was best for him with all the changes he's going through.
So what are you requesting?
I'm requesting that that be allowed still, because we have legal custody.
You just want to continue the therapist you already have?
I want to continue everything that I've set up for him in the process right now.
So that's a different therapist?
He's seeing both therapists.
So that's
Yes.
to continue both therapists?
Yes, because he needs a lot of help right now.
Do you have any problem with that? Sir?
I guess not, although my insurance probably isn't gonna like it if he's seeing 2 different therapists.
That's kind of what I was kind of wondering about the financial aspect of this. If it's not covered by insurance, are you willing to cover what is not covered?
I will.
Sounds funny to say it that way. But
So far, they have told me that it is covered by it, but if not, I guess I will figure that out in the process if it's not.
Okay. I'll order that, but if it's not covered, heck, I'm going to require the monetary obligation you have to cover unless other arrangements can be made.
Absolutely.
Schultz.
Just for my clarification, Your Honor, as it relates to the agreement with the supervised parenting time, I don't have a copy of any personal protection orders. Is that a violation of the existing no contact order?
It's not entered.
It did not.
It did not enter.
Okay, thank you for the clarification.
No problem. We clear for now?
And
Oh,
may
go ahead.
may I add?
Go ahead.
If the parties wish to use a location other than the McDonald's in Essexville, they have discretion to modify that location for agreement.
Any problem with that?
No, that's fine.
Yes. That's fine. Let's go with this, see how things proceed, and hopefully we can move forward in a positive way. Raise your hand, sir.
So with the, pending the investigation of everything that goes on, if nothing goes nothing comes of it, does that mean everything goes back the way it was originally?
No, we have a hearing on it, we address it at that time.
Okay,
That's how we address it.
okay.
Okay, can I say one more thing, please?
Why not everyone else is?
His family doctor, which he's had since he was born, has put in a, referral for him to get autism testing and PTSD testing. Would that be okay?
Yeah, do you have any problem with that?
He's already told me no, or he told me yes, he had a problem with it.
Oh, it's bad now if he has a problem.
Well, the autism thing, I don't feel is necessary, I guess, but.
Would it be nice to
Yeah,
knock it
yeah,
out
I
if you
guess it
take-
would be nice to know. But as far as like the PTSD thing, like you don't just get PTSD from a short term.
Don't.
I don't think you do you?
My research and my experience is it can be a one-time incident. It can even be small, it can, I mean, I was in the second grade when my house burned down, January 16th, 1977. It was a one-time event, and it traumatized me. Traumatized, but something I still think about.
Right.
So, I'm just going to make a finding here that I'm going to order that.
Thank you.
I'll order that. And hopefully we can rule out that one issue, but on the other issue, and that can also be addressed through the therapist as well.
Okay, thank you.
So I would go upon the recommendation of the therapist. You're both free to come.
Thank you.
Awesome. Make sure you're ready.